Can I name my trustee as someone who lives in another country? I got a brother in Canada. Can he be my trustee? My name is Philip Bruce. I'm an estate planning attorney here in Minnesota. Pretty common question, actually. And the answer to that, the short version, there's a complication here. The short version is you can name anybody you want anywhere to be your fiduciary. It's legal to do it. That's fine. I can certainly say my sister who lives in England has the ability to act as my personal representative or my power of attorney or my trustee or whatever it might be. It's valid, it works. The first very obvious concern, of course, is that person's not local, so they're going to be doing all that work over the phone or email, or they're going to have to fly in. So that's less than ideal. If there's anybody you trust and that's the key factor here, trust. If that's the right person to do it, then maybe that's just the right person to do it. But if you have anybody else you trust locally who can do it, that's all things being equal, the person who lives closer is probably just a better idea. And that's not just for other countries, that's other states as well. If I've got two kids who are just fantastic at life and they're doing great, and one's in Minnesota and one lives in Florida, it's not unusual to want to name the one in Minnesota. That's okay. And maybe even a good idea. The issue we have with trustees, so if I'm having money held aside for my kids until they're 25 or 30 or 35, you can do that, right? In a will, it's called a testamentary trust, or grandkids. You say, all right, all the money goes to my kids, but they got to be this age before they get it. If they're younger than that, then it pays for college, it pays for health care, whatever. It's called a testamentary trust, and it needs a trustee, it needs a manager. That person pretty much has to be an American. You can name a foreign person for that, but now you're dealing with foreign trust taxation. There are so many rules that are going to go with naming someone outside of the country. I universally discourage it. I've drafted that into a document before when there just wasn't another person, but I almost would rather have a professional in the States have that responsibility and have it cost money to manage that money than I would want to name a family member in another country. It is really bureaucratically not a great choice, but my point still stands that it's legal to do. You can do it. The trust would work. It would just be a real pain to administer. That's a great question. I would love to hear your questions. Please send me an email.